Good morning, everybody. I will make a start. There's a few people still filing in, but they'll soon catch up. So this morning's webinar is a relatively brief talk on what I consider to be the sort of lesser spotted corners of the civil procedure rules and the White Book, and they're all relevant to all elements of business and property work, and frankly, they're of a fairly broad application insofar as even if you find yourselves doing other areas of work, these are still relevant areas to be familiar with. And of course, you don't need an exhaustive knowledge of them. What you do need to know, however, is know that they exist. So when they come up, you are a little bit quicker off the mark to deal with them. So this is essentially what this is. It's just some interesting pockets of the White Book that in the last 12 months or so, I've found myself dealing with. And they are, as I say, lesser spotted, lesser used areas of the White Book. So it's just a run through of the more interesting ones that I've been dealing with. And hopefully you find them interesting too. So to that end, hopefully you will see the slideshow on screen. If that isn't what you're seeing and you're seeing something else or indeed something more exciting, please let me know and I'll get them on screen. But hopefully you're looking at the slides. So the first issue that I'd be dealing with is the authenticity of documents. That is CPR 32.919. And this is, it does what it says on the tin, which is essentially that you will be deemed to admit the authenticity of a document unless you serve notice that you don't consider it to be an authentic document, or strictly speaking, no, you serve notice putting them to proof that the document is authentic. The deadline's there by the latest date for serving witnesses or within 7 days of disclosure of that document. So, of course, B takes into account circumstances where there is late disclosure or some change up in the batting order of directions, as we see frankly on a regular basis when it comes to more complex cases with complicated disclosure exercises. So the first point to note on this, really important, is to know what we're talking about here. You don't have to serve this notice simply because you disagree with the interpretation of the document. So, for example, you have a contract that you accept parties A and B signed, and it's a genuine contract, but the parties don't agree as to what the contract means or whether it's enforceable or all those sort of contractual issues. That is completely different to the authenticity of the document. 3219 is reserved for situations where you essentially are saying you don't know whether or not it's a forgery or whether it's a genuine document or whether it was actually your client that signed it. So really keep an eye on that distinction because it's really important. What you don't want to be doing is banding around 3219 notices unnecessarily because, of course, it does put the other side to a fair degree of work. And if it turns out that you got it wrong, then there may be consequences, even if they are as discreet as the work dealing with 3219. Looking at the authorities, there's 3 cases there that are particularly enlightening on how this works. Unfortunately, the authorities do tell a story that really this is a difficult rule to enforce with any real degree of consistency. That's because, of course, it does put parties at real prejudice if they are unable to challenge authenticity if they're a little bit late, or indeed if at the last minute authenticity is drawn into question. So the first case of Nagy and David Game College 2013 Court of Appeal case is that the claimant brought a claim for bonuses and commission alleged to be owing under a written agreement with the defendants. In their defence, the defendant admitted the document but disputed its meaning and effect. So going back to our distinction earlier, they didn't say it wasn't authentic. They simply said, we don't agree what it means, etc., the usual contractual argument. At trial, the judge found that the document was not authentic and dismissed the claimant's claim. Now, the Court of Appeal allowed the appeal on the basis that there wasn't a 3219 notice and it wasn't open to the judge to find that the document was not authentic. So that's very important. It shows that this 3219 does have some teeth. If you don't give notice and give the other side the opportunity to prove the authenticity, you can't at trial essentially ambush them with suggestions and contentions that it's not an authentic document. That so far is very straightforward because that makes perfect sense. Going on the case of Lion Walk and Sing, essentially this is an example where the 3219 notice was served late, albeit a long time before trial. And this, without going into too much of the ins and outs of the sort of directions and the procedural matters in that case, it was all about much further down the line, one party saying to the other, well, we want a handwriting expert to consider this document. And the other party turned around and said, well, just a moment, looking at 3219, you've already admitted its authenticity. In this case, as you might expect, the judge took a broad view and essentially said, well, it is unfortunate, but it would be prejudicial to prevent one party from challenging the authenticity just because they have missed the deadline with 3219. So what we take from that away from that, is that even if you are late, you shouldn't simply advise your client that you have to admit it and forget all about it. You can take steps and indeed refer to cases such as Lion Walk and Sing. Next, the case of Mitchell and Al-Jabber. Really what this goes to is that what the other party must then do is adduce evidence that the document is credible and it is authentic. And essentially what the judge said in that case was that a fact-sensitive, evaluative approach is required. And really what to take away from this is it's in terms of how far one party has to go to prove the authenticity of a document or exactly how the court is going to weigh this into consideration is difficult, really, to advise clients on. It's incredibly fact-sensitive. It will depend on your tribunal. So really the only thing you can advise clients is simply go belts and braces, do everything you can to prove the authenticity of a document. And of course, one often starts looking at handwriting experts and so on and so forth. But that in itself is not an exact science, and we could do a talk just on that. But there you are. So that's the framework of 3219. And it's important to also note the issue of fraud when it comes to authenticity of documents. I am not saying for a moment that 3219 notices are always and must accompany a pleaded allegation of fraud. Of course, we all know fraud is a very serious allegation and should only be done if the circumstances are frankly just right. And so 3219 notice does not necessarily mean you are pursuing a case of fraud, either advertently or inadvertently. So don't necessarily get too worried about the fraud. The considerations are very different to this. For example, you may not be suggesting this was a deliberate forgery or created to assist in the litigation. It may be a document that goes back 20 years that's completely unrelated to any litigation. So keep an eye on the fraud situation, but by no means let that deter you from making what might otherwise be very helpful steps to challenge authenticity of documents. Forgive me, of course, that summary of how fraud plays in is a little bit woolly, but of course it really is incredibly fact sensitive. And I think the best I could do in this morning's very brief summary is simply say the two don't always come hand in hand. But what one does have to do is make sure that fraud has been properly considered and pleaded if necessary, and not pleaded if not necessary. The next one is a really different flavour, and that is witnesses outside of the jurisdiction. This became a particularly pertinent issue after COVID-19, when video hearings were being used much more than what they are being today. And indeed, we were all in full swing, having a remote practice in terms of court work. So tucked away within CPR 32 in the White Book is a practice note produced in July 22 by a High Court judge. And essentially, it says that we all got a bit complacent within COVID-19. And what the note does is hammers home the fact that you need permission in certain circumstances for witnesses to appear outside of the jurisdiction. This next few slides are examples from the .gov website, which is a really helpful summary and shows which countries you do need permission for and which countries you don't. And I've exhibited a couple of examples just to show that exactly in line with the practice note, you shouldn't leave this last minute. You should be on top of this straight away. If you have somebody who may be a witness and they reside abroad, you need to be on top of this issue from the get-go, because certain countries that you think might have a more favourable approach don't. So we see here that in terms of Australia, that there is no issue. You don't need permission, and everything's fine. But secondly, India, one might imagine that India, having a long relationship with the UK, would have a similar position. They don't, as you can see from there. Whereas Botswana do have a very good position when it comes to giving evidence remotely. But likewise, Pakistan, again, a country one might imagine we'd have good relations with and some agreement in place with, we don't. So keep that in mind. These just give a flavour of the stark differences in countries' approaches to this matter. Again, the USA, perhaps unsurprisingly, it is fine, as is Poland for the most part. So that is a very quick jog through of witnesses giving evidence from outside the jurisdiction. But essentially all I can say is this: check as early as possible and then try and get some arrangement in place. I understand anecdotally that when there isn't an agreement in place, trying to get specific agreement for a specific case through the Foreign Office and their bodies in the specific country can be incredibly difficult. So the earlier one starts on that journey, the better. The next one is a very, very quick note on litigant in person costs. It's important to know what the position is in this, simply because in all lines of work, you do end up dealing with litigants in person. And it's important to note that although we often write them off as people who aren't going to be either on top of the cost provisions or able to recover anything of any substance, that's not necessarily true, especially perhaps in the lower value work where the cost will be relatively more hard hitting. So where you're looking at is 46.5, and essentially the rules say this. There's 46.5 which goes on over into the next slide. They can recover time for what they've reasonably spent in the rates set out at Practice Direction 46. To summarise this, this is £19 per hour. This is an increase from £18 in 2011 and £9.25 before then. So it's had some quite large increases, and you need to be aware of that because they can, of course, rack up. A few points to note. If they do go to the effort of producing a proper schedule of loss, and they might have seen yours and copied them, that will be considered properly by the judge. The judge will also appreciate it will take them longer to complete tasks. So the usual running through of a summary assessment and saying, well, 10 hours to consider a defence is excessive. With a litigating person, that's likely not going to hold water. And next, the 2002 Court of Appeal case, legal research is recoverable. The whole thing is capped at 2/3 of what would have been recovered if that party had been legally represented. So that is to say that even if a litigating person does an excellent job of proving every hour and the research, etc., they will only be entitled to 2/3 of what a represented party would have recovered. And one might ask how that is going to be calculated and compared. I would say with great difficulty, but as broad overview advising your clients, that's what you need to know. There are cases. There's the case of R and Legal Services Commission, where a party had taken over 1,200 hours of research during proceedings, and they did allow the litigant in that case just over £10,000 for those costs and other costs. So keep litigant in person costs in mind, and I think again, all I can say is don't write them off as something that will never cause any issue, because they can cause issue. And I think crucially, and perhaps more than the costs themselves, is the quicker you can be familiar with the provisions, the easier it is to advise your client, and the less cost it will incur to your client in sorting it all out, because of course you can make sensible offers to resolve any cost disputes. The last matter is, generally speaking, getting adjournments for health reasons, or indeed adjournments. This also applies with in very much the same force with getting delays to directions on the basis of health reasons. For example, a delay in filing witness statements or dealing with disclosure, etc., etc. Of course, we're under CPR 3.1. There isn't any specific CPR provision in respect of health reasons. So what it is a case of is dealing with the authorities. Of course, there is the overriding objective, which the court will have consideration of, but we need to look at what else, and really what the authorities say about the medical evidence. So this is the part of a judgment of Mr. Justice Norris from the case of Levy and Ellis Carr, and essentially this is the judgment that you want to be referring to, both in considering your position and should you ever appear at a hearing on this matter. And essentially what this does, it sets out a shopping list of what expert evidence in terms of medical conditions should be setting out and how to consider it. So somewhat of a checklist there. Firstly, it should detail that specific practitioner's familiarity with the patient. So what we don't want to see is simply going to medical legal or a similar organisation for the first time, presenting with the litigant giving their own summary of their medical history, and that doctor for the first time giving their opinion. What good medical evidence does is set out that practitioner has seen this person before. So they have a deeper understanding of their condition and how that affects them. Likewise, the second point, it details the consultations. So if your client has seen this doctor once every quarter, once every 2 weeks, let's have the details of that so we all know. And thirdly, this is very crucial, and this requires the medical expert doctor being given some details, is identify specifically which features of the condition hinder the specific elements of the trial process. So taking a broad and perhaps crude example, if your client has temporary loss of eyesight or temporary hindered eyesight, and they're about to go through a disclosure exercise involving the sifting of 20,000 documents, the doctor can easily express that. But often it's more niche points, for example, perhaps their cognitive abilities after a surgery which will prevent them properly providing witness evidence, or perhaps it's mental health issues which for the time being prevent them dealing with certain element due to stress, or perhaps it's due to a particularly stressful issue that they're dealing with in evidence. Essentially, the options are that the permutations of this are endless insofar as medical conditions can hinder all manner of participations in different bits of the trial process. But specifically what you need to do is tell the judge, this is what I need my client to do, and this is why they can't do it. Stick to the very basic facts. And last, a prognosis as to a recovery time. So, of course, back to the overriding objective, what we're doing here is we are asking for a delay to court proceedings. We are asking the other side to stick with us and afford us more opportunity to do a certain step. If you can say to the judge, this is only temporary, in 3 months' time we'll be back able to do this step, and the trial process will continue, the directions can be adhered to, that's going to please a judge and place them in some confidence that it's appropriate to make the order delaying whatever it is, whether it's the hearing or the next procedural step. If the prognosis is vague or is very negative insofar as your client may never recover, well, the judge is going to find it difficult to justify delaying matters because there's not going to be any real tangible benefit. So it's important to consider those checklists and make sure that your evidence really does deal with all of those points. What else? Sick notes are not enough. So often clients are asked to go off and get something from their doctor, and all they get is a very busy GP writes a letter on headed paper. It's often something they've dictated, and it really, really doesn't say enough, and it effectively is a sick note. And the authorities could not be clearer that sick notes are not enough. They simply are not enough to justify delays to the process of getting a matter to trial or to adjourn a hearing. And then secondly, evidence must be in unambiguous terms. Time and time again, you will see doctors, friendly GPs who are doing their best to help their patient, and they feel sympathetic. And essentially what they do is they don't commit to say whether or not they can do something, but they write in long-winded and rather ambiguous terms, which leaves the reader not certain as to what they can and can't do. And essentially this isn't good enough. So if you do find yourself with evidence like that from a GP, unfortunately, you have to push them and say, we need this in black and white. Can they do it or can't they? And you go back with the checklist we've just run through and you push them. And of course, what you are doing is running the risk that the doctor comes back and says, well, I can't say that. And they have to expressly say they can't say that. And that might prove to be unhelpful. But at least it shows that you've engaged properly with the authorities and done a proper job of evidencing the application. And again, if you want to see a relevant case on that, it's the case of Bruce and Whitehaven District Council. Again, the Court of Appeal case. That is the end of my slideshow. Those are the points that I wanted to raise. As I said, really, really was just a brief canter through some interesting pockets of the White Book that I've come across in the last 12 months. And again, it was really just to whet the appetite of the listener to get them interested in something that they should be more aware of. So as usual, if you have any questions, feel free to pop them in the questions and answer box. But otherwise, feel free to get in touch with me at Chambers. And as usual, thank you very much for attending, and hope to see you all again soon.